Chapter 3. Outline of causes leading to reformed system. Sec. 7. The earlier common law inadequate to meet developments in substantive law. The common law system in its earliest period was inadequate to keep pace with new ideas in the substantive law of rights. It was not to be expected that any wise and complete scheme of laws should have at first been devised. The changes in legal procedure are different, and as much not to be expected as were advances in other branches of science. The earlier common law system was crude and passed through different stages of development before the final step leading to the adoption of the reformed code system. David Hume, the historian, said that to devise a wise scheme of laws for a great people at the first attempt is an exploit that surpasses the strength of the human understanding. It has often been stated that the law was adjective before it was substantive. Technically this may be true, but as quickly as new ideas with reference to rights were formed, the common law machinery was at once readjusted to meet them. This finds an illustration in the reforms brought about by the Act of Westminster, 2nd, which created the remedies for infraction of implied contracts, negligence and conversion, resulting in the creation of the actions of trava, trespass and case. Sec. 8. Changes in law. It has been the pride of legal scholars that fundamental legal principles, those which govern and determine legal rights and rules in substantive law, have changed but little in history. Conditions, circumstances, exigencies of particular conditions and particular occasions, give rise to the establishment of rules of law. There is a law of nature applicable to every situation which is presented, and which is concluded upon or established by the fair-minded and honest expression of courts. The first section in Justinian's Code is, "Justice is the constant and perpetual wish to render everyone his due." The term justice was taken by the Roman jurists to include all the demands laid upon men that they were bound to fulfill. These terms, the definitions and principles governing the rights of persons and things, have remained the same throughout the development of the Roman, civil and common law. Jurisprudence in the civil law, as with us, was the rule of things divine and human, the science of the just and the unjust. As expressed in Justinian's Code, the maxims of law are these: to live honestly, to hurt no one, to give everyone his due. In different periods of time, these general principles have been applied according to the consensus of opinion of what is right and wrong, and much might be stated in respect to the development of the common law as the English people became more enlightened. It has often been said that substantive law was retarded by the technicality of the adjective or procedural law. A study of the history of law will readily disprove this claim, and will demonstrate how quickly the law of procedure was changed to meet advanced ideas respecting substantive law, as well as to meet conditions in the administration of law. The English law of procedure was repaired from time to time by Act of Parliament until it was finally permanently improved and modernized in 1873, in some respects similar to American methods. In other respects the changes were even more radical than was our code. These changes are common to all countries. An example may be found in the German Code, passed in 1898, which went into effect January 1, 1900. It was a complete codification of both substantive and adjective law. English adjective law, like American adjective law, has now been codified, but the codes which have been enacted generally in the states of this country have not undertaken to reduce the law of procedure and pleading to specific statutory form, but have done no more than to make general provisions for the change, with occasional statutes which have provided for certain rules of pleading. The states of Iowa and California, however, are exceptions of this rule, as in both of these states the whole subject has been pretty well codified. Sec. 9. Disadvantage of the maintenance of formal distinction between legal and equitable remedies. The inadequacy of the common law system to furnish the relief which the equity system furnished gave rise to the equitable remedial system. The latter may in fact be considered as merely corrective of the common law, but in reality it became a new and independent remedial system. Its purposes possibly might have been accomplished by the creation of new original writs, the same as was done in the common law system by virtue of the Act of Westminster II. It is a matter of history, however, that the common law judges were averse to any changes and were even jealous of the jurisdiction which the chancellors exercised under the authority of the king. Instead of appealing to Parliament for further power or authority to reform the mode of procedure, appeals were at first made directly to the sovereign, and later they were referred by him to the chancellor, which in time resulted in the creation of a new system of trial for cases coming within this extraordinary jurisdiction. This resulted in building up two independent formal systems, so that parties litigant could not settle all their differences in cases which arose, for example, out of the same transaction, on which may have been connected with the subject of the action, as may now be done under the Code. A litigant at law not being able to set up his equitable rights in a legal action, had to submit to judgment at law, and thereafter had to resort to a court of equity for the extraordinary relief afforded by that system. Or in some cases he may have commenced his action in a court of equity and there sought and obtained an order restraining the further prosecution of the action at law until his rights were determined by a court of equity. It was sometimes difficult to determine whether a matter came within the equitable or legal powers of courts. But this difficulty has always existed, and still exists. There is a notion that under the code system there is not so much difficulty arising from this matter, because of the fact that there is now but one civil action and one court which may administer law or equity, as the case may require. But there is no doubt that if one mistakes his remedy by declaring inequity, he cannot by amendment change his action from equity to law or vice versa, if facts are not stated by him in his pleading which would entitle him to make such change. The improvement made by the code system in the matter of this difficulty is that if a party has stated facts in his pleading which entitle him to some relief but not that which is prayed for, the court will grant him relief according to the facts stated, without regard to his theory of the case. Sec. 10. Disadvantage of formal distinctions between the actions. Parties encountered some difficulties in the common law system by reason of the formal distinctions between the several actions. A mistake might be made in pursuing the wrong action, in which event a dismissal of the same was necessary, and a new action had to be commenced. This has been frequently pointed out as one of the disadvantages of the old system. In code procedure there is but one form of action, but the rights of action, or the causes of action, remain the same now as under the common law, and the real distinctions designated by the formal common law names still prevail. Indeed, it may be truly said that we still think and act in the spirit of the common law system. An action of trespass, or in case, has the same definite meaning and signification now as before, although there are in fact no such names. We have the same kind of actions, practically, as existed at common law. Each of them has its own rules of law, and, except when modified by statute, is subject to common law principles. It would be impossible to conduct the business of the courts without keeping in mind the essential distinctions existing between the various kinds of actions. By its very nature the practice of law must have some consistency, and when an action is brought in court there must be some way of determining what the character of the action is. And these distinctions are by no means artificial. They are perfectly material, and are necessary to the protection of the rights of litigants, as well as for the information and guidance of the court. It was the purpose of the code to abolish the different forms of action and the technical and artificial modes of pleading used at common law, but not to dispense with the certainty, regularity and uniformity which are essential in every system adapted for the administration of justice. 1. Actions for money only. Under the code embrace in reality all the formal common law actions which were also for the recovery of money only, as debt, assumpsit, covenant, trespass case and strava. Actions for the recovery of specific real and personal property under the code embrace the actions in the common law system whose object and purpose was the same, viz., replevin and ejectment, which were tried to a jury, but the formal distinction is broken down and the fictions appertinent to some of the actions have been abolished. The distinction between sealed instruments, and the consequent necessity for the selection of a certain action on such instrument, is now obviated. A plaintiff was required to show and follow a technical formula recognized as suited to his case, otherwise he had no standing in the court. If a wrong action was adopted, the error was fatal to the proceeding, However, clearly the facts of the controversy might have been before the proper court. David W. Field once stated that he came near losing a case by declaring in assumpsit on an insurance policy, when it proved to have a seal. There was a mark on it which looked like a seal, but was so dim, and the judge looking at it without his glasses said he could see no seal. These, in substance, constitute some of the main difficulties in the formal distinctions between the common law actions. Sec. 11. Vices in the form of statement. Although it required the same facts to constitute a cause of action at common law as it does now, the practice in the old system had departed from its original purity and some vices had crept into it. The principles of pleading which composed what may be called its science were rational, concise, luminous, and admirably adapted to the investigation of the truth. But in actual practice it degenerated and it became common practice not to state the facts as the rules in reality required. Instead of stating them as they were, or as they occurred, the pleader would state facts according to his own conception of their legal effect or meaning. And although it was contrary to correct rules of pleading to present a single cause of action in duplicate form, it became customary to state the case in various forms to meet the different phases or theories which the facts might assume or rest upon, according to developments in the evidence at the trial. These abuses, and others that might be mentioned, gradually became a fixed practice, and there was no definite remedy provided for in the old system against them, nor was there any disposition on the part of practitioners and the courts to correct them. On account of these vices and the flexibility of proof under the general issue by the defendant, parties frequently went to trial without any definite idea of what they were going to meet. Again, there was more verboseness and prolixity in the form of statement. All this has been remedied by the code, and the ultimate facts, those facts which parties expect their evidence to establish, are required to be stated just as they are, in ordinary and concise language. But in reality, however, the great body of the rules of pleading which composed the science in the common law system are still controlling in practice under the code. It has been contended, however, that they are in force only by virtue of provisions in the code itself, but an examination of the various codes in the different states will disclose that there is not to be found any general sweeping provisions which make them so applicable. The chief modification of the common law system of pleading made by the code was in the form of statement, requiring the facts to be stated in ordinary and concise language. Sec. 12. Of the origin of equity. Reasons for the union law and equity. The branch of our remedial system falling under the head of equitable remedies came into existence because of the defects in the remedial jurisdiction of the courts of law. In seeking relief at law, parties had to pursue the prescribed forms of action prevailing in the common law system. In the absence of the prescribed form to suit the particular case, there was no remedy. These remedies could not be molded and adapted to the particular circumstances of cases not coming within the forms of the common law cases, so that complete justice could not be done in common law courts. The result was that for many wrongs the courts could not furnish a plain, adequate and complete remedy. This gave rise to the Court of Chancery, which was designed and originated to supply the remedy which courts of the law did not afford. It has been urged that it was not the intention in the beginning to have two systems, but that the equitable system was designed to be merely emendatory and corrective of the common law system. The result, however, was that the remedies afforded by courts of equity developed into an entirely new and independent system. It was the purpose of the new Code of Civil Procedure to formulate a uniform mode of procedure, a system comprehensive and flexible, and perfect enough to be able to afford remedy for every violated right, a plain, an adequate and a complete remedy. The code brought together the two jurisdictions vesting the same in one court. There being no sufficient reason for the establishment of an original independent system, it was not a difficult matter to break down the walls that separated these two jurisdictions, and to blend the two systems of practice, and to form them into one. The disadvantage of the separation under the old system was, that, notwithstanding how fully and clearly the facts of a case may have been stated in an action at law, or in a suit in equity, if the party had mistaken his remedy in the particular court, he was compelled to dismiss his action, or suffer defeat. and commence a new action in the proper court. Another serious objection to the separation of law and equity was that it frequently required more than one suit to settle controversies between parties which might just as well have been settled in one. A legal defense could not be interposed to an equitable action, nor an equitable claim to a legal action. The legal or equitable action had to proceed to final termination, and the party with the legal or equitable claim had to resort to an independent action in another court to establish the same. Sec. 13. Attempted reforms in the administration of law and equity in England. An interesting item of history is the report of a commission upon law reform in England in 1852. The commission consisted of the Master of Rolls, assisted by 2 vice-chancellors, Solicitor General, and distinguished barristers. The report made by them of their deliberations upon the advisability of the union of law and equity is of such interest to the student that the same is here set forth. According to the present system, it frequently happens that parties acting under the advice of the most competent practitioners, lose their suits, and not only incur their own costs, but have to pay those of their adversaries, because, although they are entitled to the redress of their wrongs, or the enforcement of their rights, they have brought an action, when they should have filed a bill, or have sued in equity, when they might have had remedy at law. There is often considerable difficulty in ascertaining on which side of the boundary line between law and equity a particular case may range itself. Sometimes the difficulty is in ascertaining precisely the facts, sometimes, in making out whether, on a given state of facts an action at law is maintainable, or whether relief is in equity. Sometimes the suitor in equity is defeated at the hearing, after the expense of the suit has been incurred, by its being made out that, under the circumstances appearing on the evidence, there might be redress at law, which his advisers had not been aware of, or had thought too doubtful to recommend. The difficulty in ascertaining a fact, or in determining whether an action at law is maintainable, may send the suitor in equity to law, after the expense of the suit has been incurred. And sometimes the plaintiff in a court of law is non-suited at the trial, upon the existence of some relation of partnership or of trust appearing unexpectedly on the evidence. We think that the jurisdiction now exercised by courts of equity may be conferred upon courts of law, and that the jurisdiction now exercised by courts of law may be conferred upon courts of equity, to such an extent as to render both courts competent to administer entire justice, without parties in the one court being obliged to resort to the aid of the other. Under such a system, the number of cases where persons may at their option, resort either to a court of law or to a court of equity, will doubtless be considerably increased. But this does not appear to us to constitute any substantial objection. There is at present a large ground common to the jurisdiction and procedure of both courts. Cases of fraud, of account, and of debts due from the estates of deceased persons, may be mentioned as instances where the same subject matter are dealt with either in courts of law or equity, and we are not aware of any mischief arising from this common jurisdiction. We see no reason for narrowing this common ground, and when the proceedings of courts, both of equity and law, are simplified, and the expenses reduced, it may probably be found that the common ground of jurisdiction may be widened with advantage. The principle of rendering each side able to administer complete justice in all cases within its cognizance, without requiring the assistance of any other tribunal, has been adopted to some extent in recent enactments, enabling courts of law to grant discovery of documents, and in the introduction into these courts of interpleader, which has been found convenient and practicable. Sec. 14. Nature of union of law and equity under the Code. A brief exposition of the nature of the change made by the Code in its operation in law and equity cases will be conducive to an understanding of the matter at this point. The Code made provision so that one cause of action at law and one in equity could be united in one action, provided that both arose out of the same transaction, or were connected with the subject of the action. Again, it provided that a defendant could by his answer set up a cause of action in equity by way of a counterclaim against the plaintiff's legal cause of action, or he may set off, or a legal counterclaim to the plaintiff's equitable cause of action, provided the latter arises out of the same transaction or be connected with the subject of the action. For example, if A has a legal cause of action against B for a breach of a covenant in a deed, or a condition in any instrument, and brings his action thereon, being made by answer and cross-petition assert an equitable claim for reformation of the covenant or instrument, and the whole controversy may be determined in the one action. The unison of the two systems into one, enabling a defendant set up as many claims and defenses connected with the transaction as he may have, whether legal or equitable, avoids a multiplicity of suits. A learned writer complained of the view taken by many courts in the earlier history of the code, stating that, express as is the language of the statute, and well established as is the juridical nature of defenses in general, the doctrine has been strenuously maintained, and is supported by the decisions of respectable courts, that a defendant cannot avail himself, as a defense, of facts entitling him to equitable relief against the plaintiff's legal cause of action, unless he does it by demanding and obtaining that specific remedy, which, when granted, destroys the action. In other words, he cannot invoke the right as long as he treats it and relies upon it as a defense. If he does not institute a separate action based upon his equitable right, and recover the specific relief therein, and restrain the pending action at law, he must, at least, in the answer pleaded to that action at law affirmatively have demanded the equitable remedy, and this remedy must be conferred upon him. The change, however, was one only of form, the distinction between law and equity remaining as it was, but to be administered by one court. The walls separating the two jurisdictions were merely broken down and the two systems simplified and molded into one. Again, it has been contended that if the fundamental principle introduced by the code be honestly followed to its logical results, if its spirit be faithfully accepted as the true and only guide in the work of constructing a system of practical rules for the bench and bar, there should be no such distinctive names used in legal terminology as legal action and equitable action, certainly not action at law superscripto or suit in equity, since with strict accuracy of expression no action can be considered of itself as either legal or equitable. Such a view, however, has never obtained. The distinction between law and equity seems to be as immutable as the rocks and hills, the only change being that they are administered through the same channel. The comment of those who framed our code, touching this matter is instructive, viz., it is not meant to do more than abolish the distinction between actions at law and suits in equity. It is not meant to impair or affect rights, as heretofore recognized, or to lessen the extent of relief heretofore granted, but to grant just as much as before, only requiring that all relief, legal and equitable, formerly sought by the various actions at law and suits in equity, shall hereafter be sought by commencing every suit for it in the same way. The entire mass of remedial justice, all that portion of it which has been administered in courts of law, and all that portion of it which has been administered in courts of chancery, will remain, but be administered by a different mode of procedure. The common law will be as it has been, and so of equity. They will continue to stand to each other in the same relation, and their peculiar relief will be invoked in the same cases as before. In a word, the proposition to abolish the distinction between actions at law and suits in equity does not affect the principles of law and equity, and only changes a part of the machinery heretofore used in administering them. If the facts which plaintiff states are such as to authorize a recovery under any of the old forms of action, he may under the code be entitled to recover if he proves the facts. Courts of equity acquired a large part of their jurisdiction on the ground of the propriety of preventing a multiplicity of suits. No change was made in this principle of jurisdiction by the mode of trial provided by the code, or by the right of a defendant to assert distinct causes of action against the plaintiff. Indeed, the principle of the prevention of a multiplicity of actions and suits is more effectually carried out by the method of pleading in code procedure than it was formerly. Now in one action all causes arising out of the same transaction, or connected with the subject of the action may be asserted and determined in the one action, whether by plaintiff against the defendant or by defendant against the plaintiff. A plaintiff may unite as many causes as he may have arising out of the same transaction, and a defendant may set forth in his answer as many grounds of counterclaim or set off as he may have, whether they be such as have been heretofore denominated legal or equitable or both. In this manner it is at once apparent how much more effectually the principle of prevention of a multiplicity of suits is carried out under the code. Sec. 15. Some views entertained of the change by the code. Some make light of the change of uniting law and equity even to this day. They say that we practically maintain the distinction between law and equity now, and that it consumes as much time as formerly in hearing and determining whether the issue is tried to a jury or the court, or in the trial of a counterclaim or set off, when it is of a different nature from the plaintiff's cause of action, in which event it is entitled to a separate mode of trial. Granting that there may be some inconvenience in having two trials, one upon a legal counterclaim, for example, and the other upon the equitable cause of action, the advantages in having the whole controversy settled in one action are far greater than any inconvenience there may be. Separate trials may easily be avoided in many cases by parties agreeing upon a mode of trial, or if the counterclaim is legal, and the plaintiff's cause of action is equitable, and the defendant demands a jury trial upon his counterclaim, the court is empowered to refer the equitable issues to the jury, and thus it may avoid the trouble of two trials. This obviates the difficulties of which some complain. Under another heading, a criticism upon this point is quoted. There is, too, a lack of ready appreciation of the practice in this matter in code practice. Parties frequently set up facts by way of an apparent defense which call for affirmative equitable relief, treating the claim as a mere defense, not realizing that it is in fact an equitable counter-claim. Frequently cases are sent to the trial room for court and jury, where such an answer is made to a plaintiff's legal cause, when the answer should have been reformed on motion by so stating the facts with a prayer for affirmative relief, thus constituting it an answer and cross-petition, which is the same thing as a bill in equity in the former practice. This case should then be first submitted to a chancellor upon the issues arising upon the answer and cross-petition. If the matter is determined in favor of the defendant, it may terminate the whole action. If it be determined adversely to the defendant, then the action will proceed to trial upon the plaintiff's petition. Sec. 16. Peculiar phases which may arise in code practice. The following example may be furnished of the novel situations that may arise out of the union of law and equity in code practice. A plaintiff files a petition in equity to reform a written instrument for fraud or mistake which may be done under some circumstances under some authority, and the defendant files an answer and cross-petition setting up a contract by which plaintiff agreed to purchase property upon the terms and conditions set forth, upon which there has been default, entitling defendant to a recovery of the possession of the property, as well as damages for the wrongful withholding thereof. In natural order the plaintiff's equitable cause is tried first, because if it be well taken, it would settle the whole case. But the judgment of the court is against plaintiff. The cause thereupon proceeds to trial to a jury upon defendant's answer and cross-petition for the recovery of the property ejectment, and for damages. The plaintiff by reply seeks to set up the same claims which were originally made in his petition by way of a mere defense. This cannot be done because he elected to stand upon the theory that his claim was equitable in nature, and having been defeated in that, he cannot set up the same facts as a defense to the cause of action asserted against him by the defendant. This illustrates how effectually the matters existing between parties may be determined in the one action under the code, and clearly refutes the criticism referred to in the previous section.